Case number 112429, Vernon Burnett et al. V. Kimber Eubanks, MD et al.
Your Honor, if it please the court, Stephen Day appearing on behalf of both defendants and appellants in this case. Bruce Keplinger, who was the trial counsel, is also appearing. We would request 3 minutes of rebuttal time.
3 minutes is granted.
This is a case in which a young man with a long history of severe psychological injury or problems developed meningitis. The claim was made that the meningitis was due to an injection for pain control that was given to him. And then 4 years afterwards, the young man in question committed suicide, and the claim is made that the death was associated with pain that was associated with the occurrence of the meningitis. There was a verdict for the plaintiff, and defendants have appealed. Your Honor, plaintiff's experts in this case gave testimony that the problems associated with the meningitis, that in other words, what was associated with the alleged negligence of the defendants, contributed to the fact that this child committed suicide. They did not testify that it caused it. They did not testify that but for the negligence in question, the injury would not have occurred. They simply said it contributed. Now, it needs to be understood that in this case, this is occurring within an extraordinarily complex situation. Joel Burnett had a long history of bipolar disorder, suicidal ideation. The records reflect prior suicide attempts. This was a young man who was clearly in great risk of suicide before the meningitis event even occurred. Now we're 4 years afterwards, and there has been a death, and the question becomes, can you blame the defendants for that suicide that occurred 4 years later? A jury needs help from an expert under those complex circumstances in determining whether, but for the actions of the defendant, this would not have occurred. This is way beyond the common knowledge of a layperson, given all the complexities involved here. The motion for directed verdict was appropriately made on the basis that there was not evidence that the actions of the defendant were the cause of the death, and with specific reference in this case. The previous case dealt with the issue in general. Here the reference was to the wrongful death statute, and the fact that that statute specifically provides for recovery in the event of death for something that is caused by wrongful conduct, not by something that is contributed to by wrongful conduct. That's a statutory language. And the language of the statute, as this court has repeatedly said, has to be applied under the plain meaning of those words, and the plain meaning of caused is not caused or contributed. The dictionary definitions clearly show that contribution is, or contributing is less of a requirement than is caused. So when the jury instruction says caused or contributed, it is changing the statute. It is saying that it's going to allow recovery for a statutory cause of action that is not authorized by the statute. And that is, contrary to law and should not have been permitted.
So you think the causal requirement in wrongful death cases is different than regular negligence?
No, I actually don't, Your Honor. I think, as discussed in the last case, the but-for applies in both of them, but I do believe that the case is stronger for wrongful death because you also have the statutory language which specifically says caused. And, I understand that counsel argues that that gets incorporated into the law. The general law is incorporated into that wrongful death, but they also have to meet the statutory language of the cause of action itself, and the statute requires cause, not caused or contributed. I mean, it's that basic. In terms of the facts of the case, the trial court agreed that the expert testimony was insufficient, but construed the Wozniak case as creating basically an exception to the requirement of expert testimony. The Court of Appeals took a different approach, largely ignored Wozniak and said that the contributed testimony was adequate. And to briefly respond, because I also want to talk about the damage issue, but to briefly respond to each of those points, Wozniak, and we give 4 reasons in the brief, and I think it's pretty overwhelming and clear that he did not create a suicide exception to the requirement of expert testimony. Number 1, Wozniak didn't base the decision on the fact it was a suicide case. Number 2, later Kansas cases dealing with suicide have not ruled that way. Number 3, out-of-state cases clearly provide that there's special need for expert because of the testimony, because of the complexity of the issue. And number 4 is that it doesn't make sense. The reason that you require expert testimony is to assist the jury with something that's got a complexity that goes beyond their common understanding, and that clearly applies in this circumstance. And in terms of the caused or contributed, I mean, you basically have the same argument that we've already gone through, with the added factor that there is specific statutory language. In terms of the expert testimony, we presented you with a lot of case law that says that in order to make the case, you have to produce an expert who establishes for the jury the but-for standard, and that use of the language contribute is not sufficient. No one, not the Court of Appeals nor the plaintiff, has ever cited to any decision that is contrary to that says it's good enough to simply say there is a contribution, but that somehow is adequate to assist the jury with the issue of causation. I think it's important to emphasize here that, again, the purpose for expert testimony is to assist the jury. They need this assistance from an expert, and where they need this assistance in a properly instructed jury, because that's the law, is in determining the but-for standard, which is very complicated in a suicide situation like this. And they didn't receive that assistance. Absent that, they were left to speculate, and the directed verdict should have been granted. Talking about the jury trial, the jury instruction is essentially the same issue we already talked about, and I won't repeat all of that. It'd be in our position, though, that it's especially obvious that the jury needed to be instructed on the basis of caused rather than contributed, because that's what the statute says. Now, wanting to cover, have some opportunity to cover what I think is another rather important issue here, is the question of
economic versus non-economic damages.
Yes, I'm sorry, Your Honor. I was trying to think at the same time I was looking at my notes.
Before we get to the substance on that question, I'm trying to understand and make sure, I suppose, that throughout, from the trial court up through petition for review to this court, that you have preserved your ability to argue the merits on that. There appears that there could be some confusion about whether that's been raised only as a kind of a sufficiency of the evidence to support the jury's verdict on what was economic and non-economic damages, and then how you divide them.
Your
And
Honor,
so I want to try to understand that.
I'm sorry, Your Honor.
No, that's okay. Just enlighten me.
Okay, so we're on the economic issue, and that's...
Yeah. Have you always and consistently throughout the litigation raised the legal issue as well as the sufficiency?
The motion for directed verdict and the objection to the jury instruction both stated that there was no economic evidence or no evidence of financial or economic loss to allow the case to go to the jury on this claim for loss of attention, protection, and those items. So it is a statement that the evidence was not sufficient, that not really that it wasn't sufficient, that it just wasn't there. And that continues to be the position we're taking. But the issue here is there is no dispute in the evidence as to the nature of the damages. There's no dispute as to the fact that Joel and his parents were close, that they did a lot of stuff together, social activities, but there's also no evidence that this adult child living away from home provided any financial services at all, that they provided any kind of chores, that he gave any financial advice, that he did anything that has any kind of connection to a service or a financial benefit. So the issue is, in determining the amount of damages, that is an issue for the jury. But in how you characterize this as to whether it in fact is economic loss or whether it is non-economic loss, that is and remains an issue for the court. And our position is that when you have an adult child living away from home, because somewhat different issues in the case of a parent of a minor child, for example, but when you have an adult child living away from home, this social interchange, the playing of cards, the going to movies, the talking on the telephone, constitutes a non-economic loss. As a matter of law, it does not constitute an economic loss. And
So if I may, I'll try to restate to make sure I understand what you're saying. You're saying that you always took the position that in this case, there was no evidence of economic loss from this sort of relationship.
this is
It
correct.
was all non-economic, but your argument is limited to this case. You're not making a more global legal argument that losses of this kind are never economic.
I mean,
Do you
I
understand my
think
question?
that I'm making the argument that in this case, but I'm also making the point that where the facts of the case are, that the damages all relate to social things as opposed to something that
actual
could be
financial support of some sort.
Of some sort, that does not constitute, in the context of this case, in the context of an adult child, does not constitute an economic loss. In the case of a parent of a small child, that's a totally different issue. And I talk about how the U.S. Supreme Court in admiralty cases treats that as being a financial loss, but does not treat this situation as being a financial loss.
Okay, thank you.
The critical thing, I think, is, and we've gone through this. First of all, let's talk about it, and I don't have a lot of time here, but let's talk about the plain language of the statute. What does it mean when you talk about a pecuniary loss? And the dictionary definitions are all the same. A pecuniary loss is something dealing with money, financial. So if you apply the plain understanding of the statute, this is not an economic or a pecuniary loss. It's a non-pecuniary loss. Then you can look at the history of the statute, and we discuss it in the brief, in our reply brief, and the court has that in front of them. But the fact that originally, when the wrongful death statute was passed, can I finish my thought, Your Honor?
Sure.
Thank you. When the statute, for the whole first history of the state of Kansas, the wrongful death statute provided only for pecuniary loss. Then in 1947, they amended the statute and they added that language, which is now in our wrongful death statute, that has these specifics, including the attention and protection language that we're talking about here. And the contemporaneous decisions of this court at that time clearly stated that this added language allowed for recovery of a type that had not previously been allowed when it was a pecuniary loss. In other words, that language that we're now talking about was not adopted to change the definition of pecuniary loss. It was adopted to allow recovery of non-pecuniary loss. I think that the contemporaneous decisions of this court, the statutory history itself, when combined with the just the plain understanding of the language, should make it clear that as in this case, the evidence is exclusively of a relationship that is social in nature, social companionship, as opposed to financial in any respect. It's even nothing, even in terms of doing chores or the things that are discussed in Wentland and McCart and the other cases. For an adult child, especially when living away from home, that cannot support a categorization as an economic or pecuniary loss, and that would be our position on that issue. And I am out of time.
Very quickly, just one quick
Yes.
question. Was there any argument below about intervening causes in this case? I don't see it. I just wanted to touch base quickly to see if you agree with me.
I agree with you that there was not any discussion of the subject of intervening
Okay, thank you.
cause.
Any more questions?
Yeah, this is probably, I hope this is just a housekeeping question, and it goes to both sides. And I don't mean to catch you cold, but the evidence from Charlene Clouser was a deposition, and it's got a sticker on it, but we can't find where it was actually admitted or read into the record or what. And I don't want to catch you cold on this, but if talking to Mr. Keplinger, you can figure out how this got here. I mean, you can.
If I can defer to
you
Mr.
guys can do it
Keplinger,
in
'cause
your
you know I
right
wasn't there.
time. I'm just saying, we couldn't find it, and
This will take 1 second.
Mr. Keplinger, if you're going to speak, would you step to the lectern so our camera can catch you for the folks watching from home?
Mr. Nutter's coming up too. We were trial counsel. We both just nodded each other, agreeing that yes, it was presented to the jury.
how was it presented?
I believe it was read.
It was read to the jury, yes.
Okay, thank you.
Thank you.
Anything else? Okay, thank you.
Any more questions? Thank you, counsel.
Steve, I think this belongs to you.
May it please the court. I'm Michael Blanton, and I represent the plaintiffs and appellees in this matter, Vernon and Gail Burnett. Plaintiffs are basically accused in this case of having followed Kansas law as it's existed for decades. And although I don't generally find that to be a problem in the cases I'm involved in this case, defendants are seeking to change Kansas law in two significant respects. First, defendants are seeking to fundamentally alter the law of Kansas regarding contributing cause. And I think it's important to note at the outset, as we have extensively in our briefs, there's no question the proper instruction was given in this case. It was Pick Forth 105.01. The instructions or comments to that instruction indicate it should be given in every comparative fault case. This was undeniably a comparative fault case. This court has recognized in many different opinions that we go through in depth in our brief that this instruction is properly used in wrongful death cases, that contributing cause applies in wrongful death cases, and that it applies in wrongful death medical malpractice cases. So there's no question that we gave the instruction that's normally properly given under Kansas law. Defendants nonetheless argue that it was improper to use that instruction because the wrongful death statute uses the word caused, not the phrase caused or contributed. I think that's erroneous in numerous respects. First of all, I think it's important to recognize that the term cause is a broad term that encompasses many different types of cause. Black's Law Dictionary defines the term cause as encompassing 27 different types of cause, and Kansas cases have certainly recognized that there are many different varieties of causation. So there's no fundamental conflict between the word caused and the word contribute, or the notion of contributing cause. Contributing or cause is a broad concept that's inclusive of contributing cause as one type of cause. So I think the statute can be read, even though it uses the word cause rather than the phrase, as encompassing contributing cause. Generally, the use of a broader term doesn't exclude a narrower term. If a statute refers to a dog, you wouldn't say, but that doesn't include beagles because the statute doesn't say beagle. narrower terms that fall within the broader term are reasonably read as part of the statute, and that's how this statute has long been read. Now, defendants argue at length that the word contributed doesn't incorporate the concept of but-for causation. I think the fallacy of that argument is exhibited by defendants' own briefs. In their underlying briefs, defendants walked through the definitions of these terms, and they noted that the word cause is commonly defined as produces an effect. And they acknowledge that implicit in produces an effect is the idea of but-for causation. And defendants also note that the word contribute is commonly defined as has a part in producing an effect. Well, it's the same difference. If you have a part in producing an effect, then you're one of the but-for causes. And the defendants acknowledge in their brief that they believe the jury would have read the word contribute as meaning somebody, quote, had a part in the event that took place, in the injury that took place. So I think that's necessarily but-for causation. And you don't have to accept the wording from defendants' briefs. This court has previously made the same types of observations. In the Lawless case, 224 Can 251, this court addressed the prohibition against police officers testifying to the cause of an accident, of a motor vehicle accident. And in that context, this court considered the words cause and contribute. And the court noted that it makes no difference whether you speak in terms of actions causing an accident or whether you speak in terms of actions contributing to an accident, because both terms incorporate the exact same idea. As this court put it, quote, the distinction between causing an accident and contributing to an accident is a distinction without a difference. That's at page 263 of the Lawless opinion. I respectfully suggest the exact same analysis applies here. The distinction between cause and contributed in the context of a case where you have multiple potential causative factors is a distinction without a difference. They both speak to but-for causation. And I think it's just a matter of common sense. If in normal layman's terms, if you refer to something contributing to an event, your average person would think of that as meaning that's one of the causes of the event. Now, defendants argue that the word contribute implies a low level of causation, that it's a mere contribution, it's not really a cause. I don't think that's the way the word contribute has been treated under Kansas law at all. I don't think contribute speaks to the degree of causation. I think contribute speaks to the fact that you sometimes have more than one potential cause. That's why in a case where you just have one defendant, where there's only one, where there's no comparison of fault, it might make sense just to use the word cause because that's the only cause that you're talking about. But if you have multiple defendants, and if it's a case where you are going to be comparing fault, I think you do need to instruct the jury in terms of caused or contributed, because in fact, if you only use the word cause there and eliminated the word contributed, that could have the tendency to confuse the jury. When a jury hears the word cause, I think it may hear that word alone as meaning sole cause, the cause of an incident, exclusive of all other causes. But if you have a comparative fault case, I think the jury needs to hear a caused or contributed because they need to understand that there can be more than one cause of the incident and a cause that, or actions that contribute to the injury are a cause under Kansas law. So I think the instruction that was given was entirely appropriate under Kansas law. I think it's also important to note that it's well supported by the evidence in this case. Going to this notion that somehow the word contribute implies to the jury that they can find just some tiny little action was in some way a contribution without being a cause, that's entirely inconsistent with the facts of this case. The jury compared the fault of two different defendants, and it found one defendant 75% at fault and one defendant 25% at fault. Those are significant degrees of fault on the part of both defendants. So that's entirely consistent with the jury having found but-for causes with respect to both defendants. With respect to, and unless the court has questions about the contributing cause issue, I'll move to the damage issue. With respect to the damage issue, as I take defendants' arguments in their briefs, while they don't want to say it, they are asking this court to overrule part of this court's Wentling decision. I appreciate the questions at the beginning about the scope of the objections below, because I don't think defendants have preserved the issue that they're actually trying to present to this court now. The objections in the trial court were solely to the sufficiency of the evidence. There was no argument before the trial court that the categories of loss of attention or care were improperly presented or that they were improperly treated as pecuniary damages or economic damages rather than non-pecuniary or non-economic. As I read defendants, particularly their substitute brief in this case, there's no discussion of the sufficiency of the evidence, really. The argument is about categories of damages and how damages should be categorized. And I respectfully suggest that issue has simply not been preserved. It wasn't preserved below, and it wasn't the focus of the underlying proceedings, and I don't believe it's properly before this court.
Then can you help me focus on what was the evidence that there was a pecuniary loss due to these factors, these social factors?
I certainly can. And if I could just prior to doing that, put it in the context of some of the cases, but I will absolutely get directly to that point. As we note in our briefs, in Wentling, this court recognized that when you're talking about losses of attention or care, testimonies such as the testimony in that case regarding the couple's closeness in their marriage is evidence and testimony that can support the finding of such losses. In Huffman, the court in finding a loss of attention and care focused on the loving relationship of the couple, the fact that the family spent a lot of time together, and the fact that the decedent was a really caring person. In this case, there was ample evidence, as the appellate court found, that Joel engaged in many activities constituting attention and care to his family. Now, I would describe these as Joel devoted great care to his parents. Joel engaged in numerous and regular activities with his parents. Joel was very attentive to the needs of his parents. I would direct the court for a more detailed discussion of that point to pages, beginning at page 33 of Appley's underlying brief, where we walk through over a couple of pages the evidence in the precise places in the record where the evidence of the care and attention that Joel devoted to his parents is expressed in the record. And I could read that now if the court would like, but there's a fairly detailed...
Let's state it this way. Start on a clean slate without our case law. Where is there evidence of an economic loss, of how this had an economic or a pecuniary impact?
Okay. And again, if I could just briefly go to the Wentling case to put that in context before addressing it. In Wentling, first of all, this court noted that when you're talking about losses of attention or care, this court stated it cannot be seriously disputed that those are economic. So when this court's previously addressed that question, it certainly gave the impression that it's not even a close question. But in talking about losses of attention and care, this court noted that those losses include not only money, but anything that can be valued in terms of money. And this court noted that with respect to losses of attention and care, they have real economic value because they involved a loss that, while not easily susceptible to be placed a dollar value on, contribute to a person's welfare. And here's the type of example I get, because I've thought about this issue quite a bit before the argument today. Many of us will come to the point at some point where we have a parent that may need to be placed in a nursing facility. And obviously in a nursing care facility, there are a lot of direct services. There is provision of medical care, there's feeding them, there are things that are direct economic benefits. But if you put your parents in a really good nursing care facility, there will also be people who pay attention to your parent, who they provide attention and care to that parent. They might just spend time with that parent. They might play board games with that parent. Those things have a very real impact on a person's health and well-being. As this court said, they contribute to a person's welfare. And in that context, clearly, part of why you're paying the premium rate for the really good nursing home as opposed to the cheaper nursing home is because part of what you're paying for is that attention and care. So attention and care can absolutely have real economic value. I think if you look more broadly at psychological literature, I mean, it talks about the fact that attention and care are things that are good not only for our mental health, but for our physical health. And when we're deprived of those, that can have a significant impact on our physical health. So I think those are real losses, and while they're difficult to place a dollar value upon, again, as this court noted, they do have real economic value because they contribute to a person's welfare. I think Joel's parents have lost those things that contributed to their welfare, and they will have lost those things for the entirety of the remainder of their lives. And I think that does have economic value. One moment, please. I think it's also important to consider the fact that defendant's argument has been constantly shifting through this case with respect to damages. In the trial court and in the underlying appeal, defendants kept arguing about loss of services. But if you go to the instruction that was actually given to the jury, we didn't present loss of services to the jury. So the argument about loss of services is beside the point. Even in his argument today, appellant's counsel referred to evidence of services. But this case isn't about evidence of services because that's not what was presented to the jury. There is a body of case law regarding services, and it indicates that when you're talking about services, the evidence needs to be more definite because it's easy to value services. You can figure out how much it costs to mow a lawn. But when you're talking about attention and care, those are the types of economic losses that are difficult to value. So you can't just carry over an analysis from services to the analysis of attention and care. Even in Wentling, this court addressed both a loss of services and loss of attention and care, but it treated those losses differently from an evidentiary perspective, even though they were both economic losses. And in their most recent brief, their substitute brief, defendants are now talking about loss of social companionship. Again, we didn't present loss of social companionship as an economic loss. So the discussion of whether that was properly presented is frankly a red herring. That wasn't what was presented to the jury. The jury was presented with loss of attention and care, and the evidence in this case supports the loss of attention and care. And finally, I'd like to briefly touch upon the experts. As I take it, the argument regarding experts in this case is really derivative of the underlying argument regarding contributing cause. Because defendant's argument isn't so much that there was an expert testimony, it's that the expert testimony was in the nature of testimony of contributing cause, and they don't believe contributing is proper in a wrongful death action. So if this court concludes that the instruction was proper, that the standard is in fact caused and contributed, then it's entirely appropriate for an expert to testify in the context of that standard which applies. And I know in their briefing, defendants say there are no cases that support that, but in our substitute brief at 13, we cite 3 different cases in which courts have talked about an expert testifying in the context of contributing cause. I see my time's up. If I could have just a few moments to wrap up, Your Honor.
We've been pretty liberal today on these cases, so if you could take, I'm going to split the difference, 45 seconds? To split?
I think that should do it, Your Honor. Assuming I can find the right page of my outline. I think it's important to consider that most of the arguments that defendants have presented in this case are about abstract legal concepts, and we can talk about what the word contributed means, but there's no showing that under the facts or presentation of this case, the jury was in any way misled. The fact is, plaintiffs followed Kansas law as it has existed for decades, and plaintiffs properly instructed the jury under that existing law, and there's simply no basis to reverse the jury's verdict in this case. Thank you.
Do you have any further questions? Thank you, counsel.
Thank you.
Please, the court. Few quick points. First, we have a wrongful death statute that says caused, statutory language. We have an instruction that says caused or contributed. The use of the word or by itself tells a jury that we're talking about a different and clearly lower standard that they can use to find against the defendant than is what is the statutory language, as well as being the general rule of but-for causation. In terms of the damage issue, the objection was at trial, and it's in the record, that there was no evidence of a financial type of loss or something close to that. And that is specifically what we are arguing, that what we are dealing with here is not something that meets the definition of pecuniary. And if, in fact, playing cards with your son, talking to him on the phone, doing these things is an economic loss. What's a non-economic loss? What is there that doesn't fit? And I think that's a pretty significant issue when you look at the instruction. And we didn't object to the instruction, but this has to do with how you categorize this stuff.
How does this, we talk about abstract legal concepts, attention and care, how does that equate to a pecuniary loss? Isn't pain and suffering also kind of an abstract concept in which you have to, juries are charged with putting an economic loss on? How's this different from that?
Well, actually, it's the same. Pain and suffering is something that they get to award for, and it's a non-economic loss.
And why doesn't that then fit with attention and care?
It is also a non-economic loss, which is the point that I'm making. I'm not saying the jury can't reach a verdict on it. I'm not saying it's not real damages. We are saying, we've contended from the beginning that these are not economic or pecuniary damages. And I think it would be valuable for the court to look at PIC 17132. And we're talking about loss of attention, care, and then he put in loss of a complete family. It's protection under the PIC instruction. That's an economic loss. Now you drop down to non-economic loss, loss of society, loss of comfort, or loss of companionship. What about what we've described here makes it something to do with attention as opposed to having to do with companionship? I mean, we need to have some legitimate distinction between these two things. If for no other reason, then you're going to have double recovery otherwise. What is an economic loss versus what is a non-economic loss? And an economic loss is something that has something to do with money or with an economic value. Non-economic loss, which is a very real loss, is something like the fact that you can no longer have the companionship of your son.
You're not, just to be clear, you're not making a sort of double recovery argument. The only reason this matters is because of the statutory cap. Isn't that right? Is that right?
I agree that that's under the facts of this case, the statutory cap is the concern, and there would be no way to know whether there's been a double recovery because we don't know what the jury said. I'm just pointing out that it is important to seriously look at this issue of what constitutes a pecuniary loss versus what doesn't constitute. One of the reasons is the cap, and another reason is otherwise you do have a danger of a double recovery. But the point here is that that losses of this type, under the plain meaning, under the history, under all of it, is a definite loss, but it's a non-economic loss.
Do we have any more questions? Thank you, counsel.
Thank you.
We thank you all for your arguments this morning. The court will take this matter under advisement. Before I call the next case, I did want to announce that the court has a noon luncheon, and if counsel thinks they can wrap this next case up in 13 minutes, we'll stay here. We do, Your Honor. I'd like you on the record. Can you come up and say that? All right.
Penny Moylan, on behalf of the Disciplinary Administrator's Office, believes that we can wrap this up in the next 13 minutes.
Craig Robinson, on behalf of the respondent, Dan Philp, believe we can wrap this up in the next 13 minutes.
Excellent. Thank you. I now call the last case on this morning's docket, which will take no more than 13 minutes, according to admissions by both counsel. It's case number 118210 in the matter of Daniel Hart Phillips, respondent.
Thank you. Penny Moylan, appearing on behalf of the Disciplinary Administrator's Office. Chief Justice Nuss, I would like to request 2 minutes for rebuttal if necessary.
2 minutes is granted.
Thank you. As this court is aware, this is an original proceeding in discipline. The complaint in this case was filed by a prospective client named Alicia, and I'm going to use her first name because as will become more apparent later, I think it's relevant. Alicia had no former relationship or contact with the respondent, Mr. Phillips. In this particular matter, she had called him to get his assistance in a domestic matter. While she is speaking to him on the phone, Mr. Phillips referred to her as baby, and that caused some concern for Alicia, and so she started tape recording the conversation. We have the tape recording in the record. We also have a transcript of the recording, and it's really probably only about a minute or two of what she recorded. And at the very end of the recording, while Mr. Phillips is telling her where his office is and what documents to bring, he ends the conversation with this statement, and don't wear any underpanties. Alicia hung up the phone and then proceeded to file a complaint with our office. She also filed a police report. I do not believe anything ever came of that police report, but Mr. Phillips can speak to that if necessary. In his initial response to the complaint that was docketed, Mr. Phillips admitted to the conduct. And he said, and this is in his exhibit, volume 3, pages 8 through 10, "There is absolutely nothing said to me on our behalf that would have warranted the outlandish, crude, and totally unacceptable remarks I made toward her, without warning and totally without provocation on her part." In that initial response to the complaint, Mr. Phillips also went on to explain that earlier that day he had been at the courthouse and he had ran into a former client. And that former client was wanting his services in a new matter, and she basically made the proposition that she didn't have any money, but that she would trade sex for his services. Mr. Phillips said that he told her that that was completely unacceptable, and basically got in his car, was driving back to his office, and it started triggering all these emotions that he had had in dealing with a former wife who was a drug addict and would trade sex for drugs. And he said when he got back to the office, he called Alicia, and unfortunately his comment was basically the fallout of having not dealt with the previous issues with his wife. In his initial response, he also told our office that he immediately got into counseling. We went ahead, the review committee found probable cause, a formal complaint was filed. He admitted to all the facts in the formal complaint. Prior to the hearing, Mr. Phillips submitted a proposed probation plan. And part of the probation plan was he said he would continue in counseling. He would have his secretary sit in with all meetings that he had with female clients, and all phone conversations with female clients would be conducted on the speakerphone in the presence of his secretary. He also listed a letter of apology. We had a hearing on May 31st, 2017. At this point in time, like I said, the facts were stipulated to, but the rule violations had not been stipulated to, although later in the hearing, Mr. Phillips did stipulate to an 8.4G violation. So really what we're going to talk about at the hearing was aggravation and mitigation. And Mr. Phillips' counselor testified, and she actually did a great job of explaining why this comment was sort of a comment that was made in anger. She was cross-examined about any sort of other deviances, such as sexual addiction. She diagnosed him with an adjustment disorder. She said that he hadn't dealt with his previous wife, the issue going on there, and then currently his current wife was wanting to divorce him, and he had all this stuff going on. And basically, he just made this unfortunate comment, and that she thought his prognosis was good and that he would not repeat the behavior. Mr. Phillips then testified after the counselor, and here's where the case sort of took a turn in a direction that I had not seen coming prior to the hearing. At that point in time, Mr. Phillips testified that he had ran into this former client, and her name was Lakeisha, at the courthouse that day. And he again reiterated what he had said in his initial complaint. However, he now said for the first time that when he went back to the office and had this phone message to return a call to Alicia, that when he was talking to Alicia, he still thought it was Lakeisha that he had seen earlier at the courthouse. I was surprised by this testimony, and upon cross-examination, I said, well, weren't you really just following up on this offer that had been allegedly made by Lakeisha earlier? And he stated several times that no, it was something that was done in anger, and it was sarcastic, and it was still the fallout from these problems that we had talked about earlier. I, at that point in time, asked the hearing panel to go ahead and listen to the recording so they could make their own determination. At the end of the hearing, that I argued that his misconduct, the statements to Alicia, constituted violations of 8.4D, conduct prejudicial to the administration of justice, and 8.4G, conduct that adversely reflected on his fitness to practice law. I also argued that this misconduct would warrant 1 year suspension from the law. However, here I did a bifurcated recommendation. I said, if you really believe that the comment was just made in anger and it wasn't a follow-up, then I recommend you place him on probation if he submits an amended probation plan where he has an attorney that will be his probation monitor. If you believe that he was following up on the offer from Lakeisha, then 1 year suspension still, serve 90 days of it, amended probation plan. The respondent admitted to the 8.4G, asked for published censure to be placed on probation. He did submit an amended probation plan after the hearing panel where he had a probation monitor. The hearing panel issued its report on September 5th. They found a violation of 8.4G, but not 8.4D. They found the following aggravating factors: 2 prior disciplinary offenses, and then this is important, submission of false evidence during the disciplinary process. Basically, they did not believe Mr. Phillips' testimony that he was talking to Lakeisha when he was talking to Alicia. They listened to the tape. He was not sarcastic or angry. They didn't make any finding as to whether he's following up on the offer or not. They just basically said that deception during the disciplinary process was an aggravating factor. Substantial practice in the law was an aggravating factor, vulnerability of the victim. Mitigating factors, they placed some great weight on his personal and emotional problems, that he admitted to the facts in the complaint, his previous good character, his remorse, and the remoteness of his prior offenses. Ultimately, the hearing panel recommended the 1 year suspension, but based upon not only his conduct of the statement to Alicia, but also his deception in the hearing, that he served 30 days of it and then be placed on probation with the following conditions. Roger Falk serve as his practice supervisor, that they meet monthly, allow access to client files, etc. Office assistant, sit in all the meetings, I've already talked about that. That he continue in the psychological treatment, and that he attend lawyer groups at the WBA. Just to wrap it up real quick, Mr. Phillips submitted his affidavit, I think last week, and in that Roger Falk and his secretary submitted the affidavits, and it appears that Mr. Phillips has not been complying with those proposed probation terms. To date, he has not attended the lawyers groups at the WBA. He has not had regular monthly meetings with his practice supervisor. They met in June, but they did not meet in August, September, October. They did meet on November 29, 2017. His secretary is sitting in on all the client meetings and listening to the phone conversations. At this time, pursuant to Supreme Court Rule 211G5, a respondent is supposed to submit an affidavit showing they're complying with the probation terms. Because he has not established that, I stand on my recommendation of 1 year suspension. However, I do not recommend at this time that he be placed on probation since he has not established that he's following these terms. And I also would request, because there is no probation that he's been complying with, I would just request a reinstatement hearing that can properly address the issues, so he can show that he has properly addressed the issues that caused the underlying misconduct, as well as his deceptive conduct during the hearing.
Okay, so I got confused at the last couple sentences. You want a 1 year suspension with a reinstatement here?
Correct.
Okay.
No probation in the intervening time?
No.
Any more questions? Thank you, counsel.
May it please the court, Craig Robinson, appearing on behalf of the respondent, Daniel Phillips. On April 27, 2015, Dan had a phone conversation with a prospective client and spoke suggestively to the woman. A complaint was made implicating Rule 8.4G, which the rule states it's professional misconduct for a lawyer to engage in conduct that adversely reflects on the lawyer's fitness to practice law. A trial was held before the panel. There was no exceptions taken by Dan to this finding of 8.4G, and we find ourselves here today discussing the appropriate sanction. In support of the sanction that was recommended by the panel, I want to just point out just a few things and then give Dan an opportunity to talk about the things that I know are important in the limited time that we have. First of all, he cooperated with the investigation and all the pending matters. The date of the complaint was early May of 2016. The complaint was filed by the board in February. There was a council response. We had our trial on May 31st. We never took any issue with any of the facts. He was extremely remorseful. The record clearly shows the level of remorse and the explanation for Dan's conduct. He submitted a letter of apology to AJ, and he had letters of support vouching for his character and professional reputation, all of which were submitted as part of the record. Like I said, as I've said, we've taken no exception to the recommended sanction, which basically we are agreeing that a 30-day suspension is appropriate under the circumstances. You're not hearing me saying, hey, let's go back and try to get something less. It was a decision, a conscious decision that Dan made after counseling with me, and it is part of his, I guess I'll say, personality, that when he makes a mistake, he agrees he should be punished, and this is his punishment. We have supported his probation by a Rule 212 submission, the best that we could put that together. I think he's been largely compliant, and I just want to talk about one small complaint, or not complaint, but objection I have to Ms. Moylan's contention that he's not been compliant. There was a lot of things inside that probation plan, and one of them that has caught the eye of Ms. Moylan that she's concerned about was that he was going to go to a lawyers' meeting, which is a loose group of lawyers that have some issues in our community, and they meet on Wednesday. Well, Dan was going through his divorce from his wife, and it was just finalized. And he had responsibilities to his 2 young children on Wednesday. And he could not meet on Wednesday with the group. And so he couldn't fulfill that, and he didn't know how to get around that. So instead of getting all worked up about it, he went to other additional AA meetings and supplemented that Wednesday meeting with additional AA meetings. And he can talk to you about that. The bottom line, we believe that he is being entirely compliant. It's been a difficult few months for Dan because of not so much because of this. This happened in 15 or 16, or 15 and 16, but because of the pending divorce and the things that go with that, and the finality of that, it was a sad time for Dan. So I believe the offending conduct that adversely reflects on Dan's fitness to practice law is arrested, and that the public will be benefited and protected by Dan's continual addressing of the matter through the probation plan, which did include continual counseling. And there's one other little legal point I want to make about the contention that it was he was being deceptive in the panel. From a legal standpoint, I think you have to consider his uncontroverted testimony as a whole. No one got up there and said, well, he's lying. And I think his testimony is entitled to the same test of credibility as any other witness. There were no other witnesses, number one. So from a legal standpoint, I think his testimony of what happened and why it happened stands uncontroverted. Second legal point.
Well, there was other evidence.
Well, there was other evidence, but no direct evidence that says, well, you're a liar. No one.
You're not suggesting the panel couldn't consider the respondent's testimony alongside the recording of the conversation he was testifying about.
My next point, if I can respond to that this way.
Excuse me, counsel. We're now 4 minutes after 12. We have a noon commitment for the court. So here's what we need to do. Between you and your client, I'm going to give you 2 minutes to wrap up, okay. Or we'll come back at 1 o'clock and resume where you are right now. No. I just want to give you a choice because we have commitments.
I have a commitment at 1 o'clock at the Department of Revenue myself, so all right. I'm going to wrap it up. I just want to make one quick point and let Dan talk.
Okay.
The context, not all of the telephone conversation is in the record. In other words, the first half of it. So from a legal standpoint, we don't know what the full context of that conversation was. With that, Chief Justice, I'll let Mr. Phillips address the court.
Thank you.
I appreciate this court allowing me the opportunity to address it. I just hope that this court considers my case as important as any other case that has been heard this morning, because I know now there's very little time. Let me say this. I have been back practicing law now for 12 years. And I came back knowing that my suspension was only 2 years, and I took 4 years to come back because I wanted to have the right attitude when I came back. I have practiced almost without incident for 12 years, and I've enjoyed the practice of law. I wanted to come back because I enjoy touching people's lives in small ways. On this particular day, I didn't. I have a tendency not to charge people for their initial interview with me, because I want to be able to give them advice and let them know what they need to do. I met a woman at the courthouse who set in motion my emotional day that day. My wife, this incident happened at the end of April. My wife signed her divorce papers in May. I was walking on pins and needles in a divorce situation with 2 young boys. I came back to my office in a fog, and my remarks were totally crude and out of line. They had to do more with what happened earlier in the morning and with what I was going through in my divorce than anything else. Had I focused on the individual at the courthouse, the first individual I ran into, had I focused on her needs rather than her solution, I might have resolved part of this. And if in my conversation with Alicia I had done the same, I probably wouldn't be here today. My remark is truly an anomaly in how I approach my clients. And I take ownership of that remark. When the investigator from the disciplinary's office contacted me, and we spoke over the phone, I took ownership of that remark then. Every day I have to deal with this. And now I'm involved in a national atmosphere that deals with sexual harassment. And I've been going to counseling for well over a year and a half. I went to counseling to address this particular issue. It involves sensitivity. And when I see a new situation on the television, I don't turn it off. I face it. And I recognize that whether out of anger or some other motivation, I was part of that. I want to learn from that experience. And I don't care how old I am. May I address one other thing? I wasn't going to those attorneys' meetings because I have this commitment with my boys who are almost 10 and almost 8. I could not compromise that and be in a full custody hearing. And I must say it was a tremendous hearing. The other side submitted a bill of $22,000 in attorney's fees that they wanted me to pay. These last several months have been tremendous in terms of the pressure. But I have to say this, through counseling, I've been able to make that adjustment. And of course, my boys are my number one concern in my life. I cannot apologize enough for the remark that I made that day. And I carry that around with me. But I truly believe that in and of itself, it's an anomaly in how I treat people and how I act. I consider it a real privilege to come back and practice law. And I practice law because I think it's important to touch people's lives in a small way. When I couldn't go to those attorney meetings with those gentlemen, I worked out an arrangement now in this divorce settlement where now I can make that on the second Wednesday. And in the meantime, I was doubling up on Al-Anon meetings, which I truly believe are tremendously more beneficial. I attend one that is an all-men's group. I attend another that is an all-women's group. And I want that because I want to be able to feel the sensitivity of both sides.
Counsel, what is it you want us to do with your case in terms of discipline?
Your Honor, Chief Justice, I believe there should be some suspension period. But I know that when that ball begins to roll, it will impact the people that I represent now. And yes, it will impact my sons and to some degree the future that I'm trying to put in balance. But aside from that, what I really want you to understand is that Alicia, and I want to call her by her first name, she got caught in the crossfire of my anger that day. And my life was falling apart. As I had memories that came back and haunted me from my first marriage. I was now looking at my current marriage. I can't entirely answer that question, and I think that I have to the degree you want me to as it relates to me. But I want you to know that the biggest reason I'm here is because of what the remark that I made to that individual on that day, who was a complete stranger to me. That's something that's extremely intimate to me, and I want you folks to know that. Thank you.
Can you address your sporadic meetings with Mr. Falk?
Yes, I can. We had a significant meeting early on, and as soon as the divorce, we had another. But we have gone to lunch together at length and discussed it. We have met with each other at the courthouse. He's given me a number of ideas. And I assure you, my secretary had issues about coming up and hearing. My secretary had issues about coming and appearing before that hearing panel. She had an issue because she was upset because I made that remark. I've had her as my secretary for 20 years, and she clearly considers that out of character for me. She listens in on all phone conversations, and she is present during all meetings. I just wanted you to know that that has created a situation in my office that is extremely sensitive. She supports me, but she's at the same time upset with me, and I understand that.
Thank you, counsel.
Thank you.
You reserved some time for rebuttal, 2 minutes. Could you step here so people can see from home?
I will waive rebuttal unless the court has any
Well,
questions.
is his explanation of the sporadic meetings with Mr. Falk accurate?
I would just address you to look at Mr. Falk's affidavit. I would not characterize their courthouse,
Right.
and
Just
there's
running.
nothing about a lunch in there either. They have not had the meetings that are anticipated by the probation plan. The last one I believe was it was November 29th, but prior to that I believe was July.
Thank you.
Any other questions? All right, thank you, counsel.
Thank you.
We thank all of you for your arguments this morning and this afternoon. The court will take this matter under advisement. That concludes this morning's docket. The court is now in recess until 9 o'clock tomorrow morning.